Good morning, everybody. I'm Julie Barn. I'm the partner at Sharpe Minds for employment law. I'm covering today effectively some of the key cases that I think for 2024 that are specifically relevant to you. And we'll look at some sort of guidance around that. Some of the legislation that's coming into effect this year, and we will briefly cover the Employment Rights Bill. I mean, obviously that is still a moving feast, and so we don't want to set any precedents as to what we suggest you should start looking into. It could all change somewhat. So if you could ping me on a slide, please. Right, as you can see, I've got quite a lot to get through today. And I'm going to just start off straight away. If you could take me on another slide, please, Andrea, on a case on unfair dismissal. This case, if you take me on another slide, Andrea, is about the breakdown in an employment relationship. So you'll know that there are a number of potentially fair reasons for dismissal. One of them is classed as a catch-all, some other substantial reason. And there are a variety of reasons that have been well established in case law that could fit within that remit. Now, I think the first point I'd like to make is I've often seen in termination letters, you've been dismissed for some other substantial reason, namely, X, Y, and Z, breakdown in the employment relationship. You don't have to say you've been dismissed for some other substantial reason. That's a legal test. What you need to say in your dismissal letter is the reason for dismissal. You have been dismissed because of an irretrievable breakdown in the employment relationship. If the person then takes you to an employment tribunal, you then explain it's a potentially fair reason because it was a substantial reason. So that was the first point I thought worth making. So on this case, the claimant has dyslexia, and she'd gone through an assessment process, and the only adjustment that was suggested was that she would require 25% more time for exams or interviews. Now, there's a restructuring process in the workplace, and she had to apply for a number of reduced posts. So the respondent sent the questions for the interview to the claimant 15 minutes in advance of the interview, but she still scored poorly, and she raised a grievance, and she said that she should have received the questions 24 hours in advance. And the grievance panel disagreed. They said, 15 minutes in advance was reasonable in the circumstances, but what we didn't do was tell you when we'd sent them to you. So we made an adjustment, but it wasn't an effective adjustment because we didn't tell you we'd made it. And so what they offered as part of the grievance, they partially upheld her grievance. They said, okay, we'll start from scratch. We'll offer you a fresh interview, and we will send you the interview questions 24 hours in advance. And she was still unhappy with that, and she raised an appeal. And then the appeal panel basically said that actually that everything has been fair, you've been fairly treated, so they upheld the original decision. And she still wasn't happy with that, and she didn't accept the decision. She continued to complain, and she was sending various communication to people right up to the chair of the charity trustees, and the respondent reviewed the situation and to see whether the relationship was still viable, and they found that actually she was unmanageable because they'd made fair assessment of what her adjustments were. They had given her an opportunity to redo it all and have the 24 hours, but she was continually challenging decisions. It was taking up a disproportionate amount of management time for what is, in context, a small organisation, and they dismissed her for breakdown in the working relationship. And this claimant went to the employment tribunal, and she said that that was unfair, and she said that actually what the employer should have done is, when they've decided that the relationships were broken down for that particular role, they should have considered an alternative role. And they didn't factor in the length of service that I'd worked there for when deciding to dismiss me. And the Employment Tribunal said, actually, this dismissal was within the range of reasonable responses, that the adjustments were reasonable in the circumstances. The original adjustments were reasonable in the circumstances. The readjustments on the grievance outcome were more than reasonable in the circumstances, and her response to that meant that the relationship had broken down. It wasn't still viable, and the tribunal said that in those sort of in that situation, bearing in mind the relationship had broken down with the organisation, not like with one particular individual, that there was no requirement to consider alternatives or factor in her length of service. Could you move me on a slide, please, Andrea? And so effectively what you're looking at, I mean, it's not a new phenomenon in this case. I'm not raising this as novel law. I'm raising it as a situation where I think, from our experience, local authorities have a lot of employees that are very happy to use the grievance process persistently and remain an employee and take it all the way through the levels and continue to complain and take up a disproportionate amount of time in doing so. And I can think of a handful of cases that I'm advising on at the moment where the relationship has absolutely, broken down, and it's quite it's not a straightforward decision to take when you're dismissing someone for a breakdown in the employment relationship. But you have to do a fair review, and you have to consider whether any alternatives would be feasible. But I think the other top tips to consider in this case is communication. So in this case, it was a disability discrimination. There's an element of disability discrimination and reasonable adjustments. So if you are making adjustments, you should say what you're doing and why, and consider any additional adjustments. So ask the employee in that situation, this is what we're intending to do. We're going to give you the questions 15 minutes beforehand, which equates to 25%, which is what the adjustment is. Would that work for you as an adjustment? Is there anything else that we can do to support you? And document the answer to make it clear, because nobody likes it when they score poorly in an interview. They're always going to look at reasons to argue that it wasn't a fair process. Ensure that if you do put in place reasonable adjustments, it's an effective adjustment. It's not a reasonable adjustment if it's actually not going to alleviate the disadvantage suffered. Clearly, you do not have to tolerate a persistently aggrieved and objectionable employee, but it's a good idea to have a really independent review of the breakdown. And not all breakdowns are organisationally wide, such as this one, but they quite often take into, bring in lots of different people. I've seen quite a few where there's several grievances raised by every single person within the HR team that has slightly touched on the process that they're involved in. And as soon as you do that, your HR team or your core services team within your organisation, and if the relationship isn't good with them, then there is a trust and confidence issue. Consider whether mediation will work. Consider saying to somebody, look, we have finalised this. If you keep complaining about it, we're going to believe that you don't accept our management decisions. Right, could you move on to the next slide, please? Okay, and the next slide, please. So this one I'm going to touch on because I think it's a useful reminder of what the law actually is in terms of protection for employees on maternity leave where you have a redundancy situation. So as you will know, under Regulation 10 of the Maternity and Paternity Leave Regulations, An employee on maternity leave is entitled to be offered a suitable alternative vacancy where they're at risk of redundancy, to enable them to continue to employ to work. If they're unable to continue to work due to a redundancy situation, then they've got a right to be offered a suitable alternative vacancy. And this has often been confused, and I think it was in this case by the claimant. So she was on maternity leave at the time of the redundancy exercise, and the redundancy was reducing the number of team leaders from 21 down to 16. And she was one of the 5 lowest scorers and was dismissed by reason of redundancy. And the Employment Tribunal upheld the claim of unfair dismissal and automatic unfair dismissal on grounds of pregnancy. And this was appealed to the EAT. And the EAT made it clear that where there is a conventional redundancy, there is no right for someone that's on maternity leave to bump somebody out of their job. So the first thing that you must do is do a valid selection process. The Regulation 10 does not operate to enable an employee to be ring-fenced from a redundancy selection process. All it does is, once that process has been completed, if the employee is one of the lowest scoring employees, they have the right to be considered for a suitable alternative vacancy. So the roles that are reducing from 21 to 16 aren't vacancies because they've got people in them. They're just reducing the number of people in them. They're not the vacancies we're looking at. We're looking at complete alternative vacancies to the one that she's been removed from. And I think that's a key thing to bear in mind, especially if you can move me on to the next slide. There is changes afoot in terms of the protections for employees who are pregnant and or on what's classed here as family leave. So this is coming into effect. So it applies to situations where you have been informed of the pregnancy that is going to take that on or after the 6th of April. So any time you're informed of a pregnancy on or after the 6th of April, these new protections will be triggered. So the employee will have protection from the notification of pregnancy, and there is an additional protected period, and it goes from the first day of the expected week of childbirth for a period of 18 months. So previously, whereas you had the protection during the period of maternity leave, so if the person took 6 months, that's how long they would have protection, or if they took the full 12 months, that's how long they would have the protection. Now they're protected full period that they've notified you that they're pregnant, then a further 18 months. So bearing in mind, this isn't a protection from being made redundant. It is an opportunity that if they are at risk of redundancy and they are fairly selected for redundancy, then you have to offer them a suitable alternative vacancy if it is available. Thank you, Andrea. Could you move me on a slide, please? So, quick guidance on redundancies. The objective scoring exercise is absolutely vital. Nobody is ring-fenced at that stage. If an employee is on maternity leave and is fairly selected, then consider alternative vacancies. An alternative vacancy should then be ring-fenced for them, even if they're not due back at work for, it could be another 18 months if it is suitable and appropriate in terms of the employment location and skills. So that's the way that you should operate, that they have it at the time that that their job no longer exists. Could you move me on a slide, please, Andrea? So I know I'm probably teaching so kegs here, but redundancy guidance, early consultation. I've seen a number of complaints this year from claimants in the Employment Tribunal where they've said that my employer has known for 6 months that they're planning to do this restructure. They didn't tell me at an early opportunity. In that period of time, I had no idea, and one allegation. I paid for a new kitchen and got a new car. Had they told me, I wouldn't have spent all that money. I mean, and it's not your responsibility to manage somebody's money in that way, but early indications, if you're going to be doing a restructure and you know it's going to happen. Now, I know in a lot of local authorities you have to then go through a process where the restructure and any of the financials around it have to be approved at a different level. But indication to the team that you're considering it, even consultation about what's working, what isn't working, so people feel like they have some sort of input into that process is usually helpful, because what often goes wrong in redundancy and often why you have claims is people feel the loss of control, that effectively by the time the restructure consultation is triggered, they feel the decision's already made. You're going to do this. You've already decided what you're doing. You've not considered us at all, and they feel that the consultation's a sham. And so do think about that carefully. The consultation should be effective. Document everything. It may not look necessary, but every meeting should be documented. The selection criteria should be really clear, should be explained, should be subject to consultation. Communication, as I say, is key. Almost all tribunal claims raised because of issues with communication. And consider carefully alternative employment. Next slide, please. So we're looking now at sort of family-friendly rights and flexible working. If you could ping me on a slide, please. So this is already in play. So flexible working is now a day one right as of 6th of April 2024. I've brought this back in because I think there's still some lack of understanding for managers about what their responsibility is in connection with flexible working. I've had a number of cases this year where I think that had the managers understood what their duties were in respect of flexible working and what they have to do to justify rejecting any application, then it would have been a lot simpler. I had a question at a training that I ran the other day by a very senior manager who said, because I spoke about flexible working, often people want to work from home. And he said, but that's not flexible working. If your job is in the office, then that's your job in the office. And I said, no, flexible working is now the right to request to work in a different way, and he just hadn't cottoned on to that. He didn't understand that as a concept, and I think it's something that because of COVID and because we all worked remotely, more people now want to do so more regularly. Some people do not want to go back to the office, and I think you've all faced those struggles, but more and more people are going back to the office. But this day one right means that somebody could accept a job which is effectively office based and turn around as soon as they start and say, right, I want to work flexibly and I want to work 3 days a week from home, and these are my reasons. And you can't just reject it. You have to go through this process. You have to explain why you can't meet those requests. And you have to do it within that 2-month period. And that is the key. There's so many delays in processes that if you don't do it within that key, you've breached that time limit, you've breached their rights, and they could bring a claim, and you're on the back foot straight away. Could you move me on a slide, please? So I'd also say that flexible working applications are often intertwined with disability and the duty to make reasonable adjustments, often intertwined with carer rights or employees who have childcare responsibilities, and therefore the potential that a rejection of an application could result in a discrimination complaint is quite high, and therefore I think it's something that needs to be taken really seriously. The standard business reason, obviously we all know what the business reasons were that are set out in the original flexible working regulations, but if you just pipe off those without any context to your situation, it looks like you haven't considered it at all. You've just gone, no, I don't like the idea of that, and just sent out that. So really think about it carefully, explain the reasons carefully, compromise if possible. If you need to extend those time limits, you can do, but it must be agreed in writing. And extend all the dates that are yet to take place, not just the next stage. I've just put there the ERB, so that's the Employment Rights Bill. So one of the proposals of the Employment Rights Bill is any refusal of a flexible working request must be reasonable. So the 8 business reasons, the plan is they will remain the same, but you've got to explain in writing what the ground for any refusal is, why that refusal is considered reasonable. I mean, I don't think that's necessarily a big change from what we've got now. What it suggests to me is that the government doesn't think that the decisions taken are necessarily reasonable. So I think it's just about justifying your decisions. Thanks, Andrea. Next slide, please. A quick one here. Carers leave coming in 6th of April 2025. Pretty certain quite a lot of you already have guidance and policies in place in terms of people's rights to take carers leave, but this is an unpaid right for leave. It's a right from day one of employment. It's not instead of the other rights, so it's to supplement rights to time off for dependents and other parental leave, etc. It can be taken in a variety of ways: full days, full week, half days, a combination of them. They must have a dependent who has long-term care needs. They have to give notice, so it's a similar notice that they have to give for annual leave, so double the amount of time they want to take. You can ask them to postpone the leave, but you really need to have a very good reason to do so, because if they need to take that leave off and they're willing to take it unpaid, then there must be a reason why they need it. So think about that very carefully. And there is a protection from detriment for taking the leave or seeking to take the leave. So it's something just to bear in mind. Update your policies, consider how you're going to apply this and how people should apply for this leave within your organisation. Next slide, please. Oh, right, move on again. So we've got a couple of whistleblowing cases that I wanted to cover. So this one is quite an interesting one. Basically, the Pit Blado, I don't know if that's how you say it, but that's how I'm going to say it today. He worked at Guy's and Thomas's foundation. In 2022, he wasn't that impressed with the pay rise he was given. He didn't think it adequately affected his job performance, and there must have been something along those lines that was set out in his contract. So on the 6th of July, he sent an email to everybody, 165 employees, criticising, sorry, I've spelled criticising wrong there. Apologies, picked it up right now. Some of the respondents' practices, including diversity, equality and inclusion initiatives on recruitment. He talked about salary and training sessions. So with full-on email, and he named names of senior employees. So initially, the respondents invited him to an informal disciplinary hearing because people were quite offended and unhappy with his email, and then they commissioned a whistleblowing investigation, and they commissioned a solicitor's firm to undertake this whistleblowing investigation, and he argued that this solicitor's firm were not independent enough to do an investigation. And the outcome of that investigation was that there was no qualifying protected disclosure identified. So the respondent then said, all right, then we're going to start disciplinary proceedings. And he resigned initially with notice. And he said, will you pay me in lieu of notice? And they said, no. And so then they said, right, we're going to continue with the disciplinary proceedings during your notice period. So he resigned with immediate effect and brought a claim for constructive unfair dismissal. If you can move me on a slide, please, Andrea. So the Employment Tribunal said there wasn't a protected disclosure. They said, whilst there was a disclosure of information, most of the content was his own personal opinions on diversity, recruitment and remuneration. They said that they didn't accept his argument that this was a charity that was linked to the NHS, and therefore it's in the public interest that he raised these concerns. They said this is an independent charity, and this wasn't an argument about the misuse of funds, which would potentially have been in the public interest in respect of an independent charity. It's not about improper conduct. They didn't accept it. Excuse me, 1 minute. I'm going to have to cut. Apologies. They didn't accept that it was a breach of a legal obligation. And they said, actually, circulation to all the staff does not meet the requirements for a protected disclosure. The appropriate recipients would have been senior figures in the organisation, or if necessary, regulators or other bodies with the power to investigate. But sending an email universally in this way didn't target those people that could actually address the issues that were raised. And they also said that it was relevant. And I think this is key, because I think this comes up regularly. It wasn't in his mind when he sent the email that he was a whistleblower. He didn't consciously say, right, I am unhappy about these things. I think that these are this. I'm going to whistleblow effectively. He only attached that label to it when he wanted to bring an unfair dismissal claim. They also pointed out the tone of the email included gratuitous personal attacks on named or identifiable individuals, runs counter to the purpose of protected disclosure. While free speech is to be respected, it's not always without consequences. The unwarranted accusatory tone moved the email away from responsible whistleblowing. I think this is a really good outcome, because I think we often get cases where people raise grievances about things they're unhappy with, or they raise them in such a way that is really unnecessarily combative. And actually, you all have solid whistleblowing processes. If they consciously want to raise a whistleblowing concern because they feel it's in the public interest and they want it addressing, then there is a channel to do that. If you can move me on a slide, please, Andrea. Oh, I thought I had another slide there. So I think in that case, I think what I would say is it's really important that you remind people regularly what your whistleblowing policy is and why they should use it, and if there's something in a grievance that seems to touch on that, directly deal with it, because the sooner you know that they think that that's what they're doing, the better, because then you can adapt your process to suit it. Right, so this is another one that I think is of interest. First Great Western Limited and Moosa. And the claimant was employed initially at Ealing Broadway train station. He raised a written complaint and a grievance in 2012, and he was dismissed because of it. And he brought a claim for unfair dismissal, whistleblowing, and they settled it and reinstated him, and they moved him to Paddington Station. So he was moved away from the people who all knew what the process that he'd gone through. And in 2018, there was an incident at the station that he witnessed, and the police were called, and effectively the complaint was that a member of the public had assaulted one of his colleagues, and the police viewed the CCTV evidence and they said there was no assault. So the respondent then suspended the claimant and his colleague pending an investigation, and they did a really bad investigation. It was really flawed, and they basically ended up with allegations that the claimant had assaulted a member of the public and also put himself at risk, and that he'd given a false statement. And they dismissed him, and the employment tribunal basically said the respondent had subjected the claimant to all those things because of the whistleblowing, even if the individuals didn't know that he was a whistleblower. There was a collective knowledge at the station and within the organisation about the claimant, which was prejudicial. And the Employment Appeal Tribunal upheld those findings. I think this is really important, because I think within a large organisation you do have staff that move from departments to departments, and you do often get a view that a feeling about that person or what they've done or anything like that does move. People get to know, and I've certainly seen it. I've seen a case where you know, there've been lots of, an individual's moved into a team, been lots of problems with them, and then they all raise a grievance against them, and they say, we now know that they had the same problems with them in the last team. So these things do get passed on, this sort of feeling that someone's a troublemaker, and it's really important to think about that carefully if someone is a whistleblower. Can you move me on a slide, please, Andrea? So, as I say, annual reminders of your policies. Please tell people if you want to is whistleblowing, we really want to hear it, we want to resolve your concerns, but follow the proper process so we can investigate properly. A reminder to be aware of that culture of ill will against an employee who raises complaints and grievances. It's really what we often do well is investigate the grievances, but not manage the fallout as a result of grievances being raised within a team. Ensure you can appoint an investigator who's willing and able to be completely impartial and not influenced by others' views of the employee, and that can be really difficult. And very briefly, there's a recent case that extended whistleblowing protection to a trustee of a charity, and I expect that case law will be extended to discrimination law in due course. I can't see why volunteers shouldn't be protected by the Equality Act provisions anyway, but that's just something that I thought was worth highlighting. Next slide, please, Andrea. Right, discrimination. And first of all, we're looking at race discrimination and a case that's this last year in relation to an accent. So we've got some background cases where this has come up previously. So you can see there's the Royal Mail Group that was a Scottish postman. The tribunal found that it wasn't race discrimination. The manager couldn't understand him, not because of his accent, but because he spoke too fast. And he had a tendency to speak faster when he was angry, so his claim did not succeed. You can see Ryan and Robertson, a bus driver, believed he'd been discriminated against for his Liverpudlian accent, and that failed because they said Liverpudlian accent was not a particular national origin. I think you could argue it's an ethnicity now. I think it's a cultural thing. I don't know if you could run that one again. But Kelly Hu Hing, I think, is a case that was in favour of the claimant. But it's got a different slant, as you can see this. The claimant had been mocked because of their nationality by others, because they're imitating the Irish accent and dancing like a leprechaun. So there's a feeling of ill will in that is more obviously harassment. If you can move me on a slide, please, Andrea. So this was the case last year, Carozzi and University of Hertfordshire. So the claimant was of Brazilian nationality, Jewish heritage, but she was employed by the university in a 6-month probation. It had been extended twice, so she wasn't doing very well in her probationary period. And then she resigned and she claimed race discrimination because of her nationality. And the employment tribunal basically said, no, it's not harassment because they said that basically an accent it can't be harassment because it was connected to the accent, and the Employment Appeal Tribunal said the assessment of harassment was wrong. That the accent may be an important part of a person's national or ethnic identity. Comments about a person's accent could be related to the protected characteristic of race, and criticism of an accent could violate dignity. They said that this doesn't mean that any mention of a person's accent will amount to harassment. It has to be considered in context, whether the comment was unwanted, related to race, and had the other purpose effect of humiliating them or violating their dignity. And this is a difficult one, really, because it's not unusual if someone has a really strong accent for people to struggle sometimes in understanding what they're saying, but by raising that, there's automatically a trigger of this is to do with my accent, and therefore it could be to do with my race. If you can move me on a slide, please, Andrea. But the key takeaway is that if there are concerns about how an employee is understood, they've got to be considered really carefully. They've got to be handled really sensitively. And it may be that the individual talks too fast and is asked if they can slow down their speech. There may be other things that it could be. So I'm not saying that this is definitely a deal breaker. In certain roles, communication is absolutely key. And if someone is not, if you're not able to understand them, then that particular process, that particular role isn't going to be effective. You need a really good explanation as to why there are issues, why it's justifiable to raise it. Next slide, please. Disability discrimination. Next slide, please. So we've touched mostly in this session, these slides on employees that have are either neurodiverse or have other unseen conditions, should we say. So this one, Bradley and Royal Mint, I think is a really bad decision, but I'm going to tell you about it anyway. So the claimant was at a really senior level, HR director in the Royal Mint. She had depression, anxiety, and a diagnosis of ADHD. The employer knew all that, so the disability wasn't in question. In 2019 and in 2021, she'd attempted to resign. The chief executive had sat down, spoken to her, and realised that actually it's her illness that is leading to her decision to resign, and had refused to accept the resignation on both cases because she was unwell. Not many would go to that length, I'd have to say, so it shows that they were trying their best to be really reasonable. In 2022, she had a clash with the executive team, and everyone thought it had been resolved, and there were no outward signals that she was suffering with her health again. But 4 weeks later, she resigned, and the chief executive sat down with her and asked her the reasons why. And she said, it is not related to my health. You know, I want to do something different with my career. I want to go and work in London. I want to do all that, you know, I want to work here, there and everywhere. I want to do different things. So they accepted her resignation, and they started the process of recruiting, and she was involved in putting those papers together. And 3 weeks later, she tried to rescind her resignation, and the chief executive refused. She went to the employment tribunal, and it is a decision of first instance, so it's just at the employment tribunal stage. If you can move me on a slide, please, Andrea. But the tribunal found that this was unfavourable treatment in consequence of a disability, so a Section 15 claim. They said that the unfavourable treatment was the refusal to allow her to retract her resignation, and the disability had caused her resignation, even if she said it hadn't. And while the employer had a legitimate aim for refusing the resignation, which, you know, operational integrity, expediency, stability of the team, those sort of things, they'd not considered less discriminatory alternatives to achieve that aim. And also they'd failed to take medical advice at the time. Now, I personally think that they did everything that they should have done, and actually it was reasonable to accept the resignation, and it was reasonable to not accept the retraction, because I think at that time they're constantly resigning and then saying you want to come back is really destabilizing for someone at a really senior level, and I don't think that context was fully understood. But it's something to bear in mind, that where you have somebody who has a condition such as ADHD or other neurodiverse conditions or anxiety and depression, where they make a decision that appears to be contrary to their best interests, you have to look into it carefully before you act on that decision. I think that's effectively the only moral to that story. Next slide, please. So other cases that we've had to consider, we covered previously the ACOM and MALON, so dyspraxia at the recruitment process. Make sure you adjust the recruitment process if somebody asks you. Duncan and Fujitsu Services. This was the employee with autism who had difficulties in oral communication, and he basically was told that when he was off sick, he had to call in, and he said, I really struggle with communication, I'd like to write in, and they said no, and he wasn't calling in, and so they didn't know where he was, so they called his mother to talk about his him being off sick, and obviously breached his confidence. So don't do that. Do think carefully about when you have next of kin on there, only use it where it's absolutely necessary. Rackham and JAC. So this is a case where the JAC is the Judicial Appointments Commission. So they set these tests for all new judges, and the applicant had with ASD wanted the test to be changed to simplify the written skills test or allow them to do a practical test. And the JAC said, no, this is the test we need to do to see whether you're at the standard you needed to be a judge, and the tribunal accepted that. You see at the bottom Crawford and the Chief Constable of Cumbria Constabulary. I think if you come on the next slide, please, I think I might have covered it. There you go. Yes. So this was a finding of direct discrimination and Section 15. So this is an employee who had autism and dyslexia. She disclosed them both when she applied to be a police officer. She didn't need to. They weren't disclosable conditions, but she disclosed them both. They had medical reports, which they maintained, which they didn't need to do. And then when she applied to go on the firearms course, they sent her for a further medical test because they were aware of her autism. And that test said you basically need to assess whether you're happy with the risks, so they looked into it further and they said she couldn't do the course. There was nothing in any of the assessments or medical reports that indicated that her ASD meant that she needed adjustments in the workplace, and as such it was direct discrimination. They were basing their decision on fears of the unknown effectively. Next slide, please. So key takeaways, we're getting more and more disability discrimination claims. I think we've had in the last year, I'm only aware of one tribunal claim that we've done as a team, we've supported clients with as a team, that hasn't included discrimination. It's far more complex claims, and disability discrimination by far is the area that is increasing. So consider carefully, if you know an employee has a disability, do not make assumptions about neurodiverse conditions. Speak to the individual, go back to medical reports that you have, only make the adjustments that are considered necessary, not the ones that you think might be necessary. Document your justification for any decision which could be considered unfavourable. Justify why, consider all lesser options and why they're not feasible, and document that. Use your occupational health very, very carefully. Make sure your occupational health give you comprehensive reports that you can use. So make sure they get the right information beforehand as background information that can then feed into the report. Communicate with the employee, find out what they need, find out what adjustments, document that you've actually done that. Reasonable adjustments are fact specific. But that doesn't mean you need to lower expectations or requirements for entry into a role in order to enable somebody to do it. So ordinarily, if you've got a job, if that's the job you need doing, you do not need to completely change that job to enable somebody to be able to do it. But you need to explain what you've done to try and make adjustments and why that's not feasible. Next slide, please. So practical experience, as I say, we've had a lot of disability discrimination claims over the last 12 months. One of the key issues comes out is knowledge of disability, and we often get the response, well, they didn't tick the box on the application form that they were disabled, or it didn't come out in the medical report when they had their health clearance before they started. That doesn't really matter. They don't have to tell you, they don't have to disclose it, but when the impact of that condition becomes apparent, then you have to look at what you do know or reasonably to know, and then investigate further. What is also a really good idea is once you've done a comprehensive review, if you do have somebody who has a disability and you do have an occupational health report and you have adjustments in place, that shouldn't be a concrete plan. It should be fluid. It should be something that is considered regularly with the employee and updated if necessary to make sure that those adjustments are still effective to alleviate the disadvantages. Consider some form of disability passport or tailored adjustment plan, and this is something that can move with them. So they move from department to department. They don't have to go through the whole process again. They don't have to assume that somebody's passed on that detail. You don't have to think, oh, well, can we pass on that detail because it's confidential? This is something that you talk to the employee with. You agree with them what goes in that. You agree that that's something that will be passed to the next line manager. So the next line manager will be aware of what they require to support them in the workplace. There's often that disconnect if there's new managers come in, they're not aware of the background, they start doing things slightly differently and everything falls apart. Fair management of sickness absence procedures, it's not a tick box exercise. Think about the context, what are the reasons why they're off sick, see if you can adapt it to suit the situation. Next slide, please. I put this in here because there was some assessment. So the gender pay gap has gone up last year, which is not a great sign really. And so someone has worked out that as of November 2024, women worked for free in comparison to the pay that men got. So it's massive. If you look at it in that way, it's a massive distinction, and it's something that is definitely in the minds of law firms who like to do collective claims, should we put it that way. And so you'll all be aware of the claim, the equal pay claim against Birmingham City Council. There were 6,000 equal pay claims. December 2024, they've reached an agreement. Don't know what the agreement looks like, but the liabilities that were discussed when the decision was made, to find in favour of the employees, we're talking about 760 million, and it effectively pushed the council into bankruptcy. It's not a situation anybody wants to be in, but we all need to be aware of it because very aware that certain law firms will be scouting for their next clients. Next slide, please. So these are the things that we think you should be very aware of. If you ever asked about equal pay questions, there's no legal obligation to answer them, but do answer them, and then at least you're aware if something is afoot, you can review it quickly, effectively, and address it if necessary. But being forewarned is being forearmed. It's really worthwhile dealing with that straight head on. Limit having multiple pay and grading scales in one organisation to avoid inconsistency. Cut out any discretion. Be transparent about pay and grading systems within the organisation. So where people start on the system and how they move up. Have up-to-date job descriptions that accurately describe the work that people do, with consistent job titles. The things that we have seen that I think are of significant risk are acting up allowances, honorariums, those sort of things where they're awarded without full sort of competition. They're awarded on the sometimes on the discretion of the manager. They often cause issues within a team, so very careful of those. Next slide, please. There you go, I've already put that there. Do equal pay audits, equality impact assessments. If you've got any performance related pay, make sure it's clearly defined, it's achievable, and it's fair criteria. This was a recommendation that I saw that I think a lot of local authorities will have a system where you have pay protection in a restructuring situation where if they have to drop down a grade, they're protected for a certain period of time. Make sure you can justify that length of time, because otherwise they're doing a job for a higher salary than people that are comparable doing the same job. So think about that. Equality and competence pay. Make sure people are paid based on their knowledge, skills and ability rather than job title or position. So they need equal access to opportunities to develop. Right, next slide, please. Right, and
I'm back, so I can pick this up if you want, Julie.
There you go. I'm going to pass on to David. I didn't know if he was there or not, but there you go. Pass on to David to cover this.
Hi everyone. So this has been around for a while. This is coming in. So this is the new neonatal leave, paid leave for employees. It is a day one right, and it's for parents whose babies are admitted into neonatal care up to 28 days old, and they have a 7 days or more continuous stay in hospital for some form of treatment. Employees are then able to get up to 12 weeks leave in addition to any other parental leave that's out there. So again, it's a bit like the others. This is not a supplement. This is an additional. Sorry, is a supplement. It's an additional element to the leave, and it's planned to come into effect this year on the 6th of April. So whilst this has been effectively law for a while, it's now actually coming in on the 6th. I think the only thing to understand really on this is where it fits in there, and I think most people can tack it on at the end, purely because I think it's still based on if certainly someone takes maternity leave, then takes neonatal leave, they've taken something different, and it could end their maternity leave accidentally, but ultimately it can be tacked on at the end, and it must be taken within the 68th week of birth. And then obviously the statutory pay on top, and that's 26 weeks of employment by that point, and you're earning, I think it's £123 a week or whatever the minimum earnings is, but obviously that will go up each year. So that's just something to keep an eye out, that will be coming in about 2.5 months time. Next slide, please. So yes, the dreaded employment rights bill, this is going on and on and on. Obviously most people will be aware of what's kind of coming in and what people have been seeing. So obviously things like day one rights, right to bereavement leave, parental leave changes, menopause action, sick pay from day one, and so on. And obviously the big thing about banning fire and rehire pretty much as an alternative route to doing that. The bill which came out of committee earlier this week and has had 40 pages of amendments added to it. So it is a growing beast. But I think it's to say at the moment, this is still very early on in the parliamentary timetable and its review. It's not even touched report stage or the House of Lords yet. So whilst these things are there, take everything with relative pinch of salt, because obviously the government can and will change these things. There has been a significant amount of pushback by a lot of industries in relation to some of these things. We did have one question before the session about sort of timeframes when these things come in. I think at the moment the easy answer is how long is a piece of string, and it does really depend on how quickly this bill passes through the houses and reaches royal assent. I think the only one at the moment I've seen any sort of time frame on is when these day one protection against unfair dismissals quote probation comes in, and that's likely to be August 26. Redundancy and restructure sometime in late 26. Other things all require consultations and calls for evidence. So on the next slide will be things about 2P, but things on 2P, 0 hours. We're not sure because the consultation only closed last month. But 2P and right to switch off and a couple of other things all need calls for evidence that have yet to even go out and are likely to go out either soon or early in 2025. So the next one, the 2P update, again, this is buried somewhere within the Employment Rights Bill and affects public procurement. And it's a new obligation, or will be a new obligation on public sector when there's an outsourcing of public sector contracts and harmonisation of terms. So obviously, as most people are aware, 2P generally forbids harmonisation of terms. It's just harmonisation. You need to have an ETO or economic, technological, or organisational reason. However, what this is the government's attempt to what they say stop a two-tiered system of ex-public service employees who have been transferred out of public sector who have either beneficial or less than beneficial terms compared to their comparators in the private sector who are working on the same contract. So effectively now the new update is you harmonise these terms, and an authority should be pushing for harmonisation as part of this procurement to whoever's terms are the best. The big concern about this is it's likely to increase costs if they're taking, one public sector employee and they have 100 private sector, and they've got to update 100 private sector contracts to the better terms, and also what comes with it. So does that include membership of the LGPS, for example, or other things that local governments might have that are beneficial that private sector doesn't have? There seems to be quite a lot of concern about this. There is a plan for a call for evidence to go out at some point in 2025. Once that goes out, we will update people, because I think a lot of authorities are going to have a lot to say about this. I think when I told my procurement team at Sharpe Pritchard about this, they were very concerned about it, as it seems to substantially change how procurements could be done, as it will add an amendment to the Procurement Act, which I think is due to go live next month. So it is something that's a concern for quite a lot of people. But at the moment, like I said, the bill is still draft. They've changed the bill on this already. It used to be 2 conditions, now it's 3 conditions that have to be met in relation to a public sector contract for services for this whole thing to be triggered. So I would expect further amendments, especially after this call for evidence. But we're not looking at this anytime soon, but it's still something to be aware of coming through. So that's really what's there on 2P and procurement for public sector. And I think that is the end of my slides as well. So next slide, please, Andrea. Yes.
Fab. Thank you, David, for just finishing off there. We have one question in the chat box. Unfortunately, I'm not quite sure what it refers to. What legislation needs to be accounted for in the council's review of this year's pay reporting? I think if that's in connection with equal pay, I think that is all set out in the sort of the audit requirements for an equal pay. But if that's not what it is, just message us separately and we can clarify that for you. So if anyone has any other questions, please do pipe up. Otherwise, I think we've got a final slide. Yes, so what we're planning to do for the next few sessions is a series on disability. As it's highlighted, I think this is the area that we're having more and more tribunal claims. And there's 2 reasons for that. One is that it's more and more people are claiming disability, but also I think it's one where we could get it with the best will in the world, we can get it wrong. And so what we're looking at over the 4 months is a whole series on navigating disability rights in the workplace. So please do sign up if you're interested. Obviously, you don't need to come to all of them. They'll all be recorded, but let us know also if there's anything else from today's session that you'd like further information on. If there's other than that, I really hope you have a lovely Wednesday afternoon.